is to conduct the electoral process. The operational phases of the electoral process are detailed very minutely in provisions of the Representation of the People Act. These provisions are a virtual roadmap for the entire electoral process. Noteworthily, Parliament in section 99 of that said act has considered 15 days as being the time adequate for the completion of this process. To institute the necessary checks and balances for these processes, the Constitution and other legislative instruments have created, and through their interpretation by the legal authorities, have created varying jurisdictions in the court to supervise, guide, and where necessary, in exceptional circumstances, to direct these processes. These include the court's constitutional, supervisory, special, and ordinary jurisdictions, all of which may arise and may be invoked in different circumstances, largely with a view to ensuring that the electoral process flows smoothly and expediently. The Elections Commission, headed by its chairman, is charged with shaping policy and with providing administrative and logistic guidelines to ensure the efficiencies of the operational and administrative aspects of the electoral process. At the risk of oversimplifying the issues, I wish to draw an analogy between the GECOM hierarchy and the anatomy and physiognomy of a human being. The chief elections officer being its shoulders, the returning officers and the other line election officials operating as its arms and legs, with the commission standing as its head, complete with its brain, eyes, ear, nose, and mouth. A fail-safe mechanism is also afforded the commission as a collective by Section 22 of the Election Laws Amendment Act to deploy remedial administrative and logistical measures to remove difficulties which may arise owing to the vagaries in the electoral process, and so as to guarantee efficacy and efficiency in the operational phases. Section 140 of the Representation of People Act can be likened to a helmet for added protection, so that when, after playing to sold-out crowds and rave reviews by electors, elections officials, political parties, and observers both local and international alike, and culminating in record-breaking turnout at the polls, Guyana Elections 2020 quickly descended into a virtual stalemate from the very day after the elections. Recourse was had to the courts for its assistance. Some 2 weeks after elections day, and after at least one previous foray into the halls of the Constitutional Court, the appellant, Yulita Moore, a citizen, petitioned the court in what appears to be an attempt by her to move the electoral process forward. By fixed date application dated 17 March, Moore prayed for some 25 reliefs in her effort to move the process forward. The 15-day period contemplated by the Act having already elapsed. The reliefs prayed for by the appellant were several and varied, and contemplated myriad aspects of judicial review, constitutional, and public law. For the most part, they touched and concerned the workings of the Guyana Elections Commission, but even at a cursory glance, were not generic in nature. Essentially, however, they could be narrowed into two broad categories. Firstly, the failure to declare the results of the national and regional elections, and secondly, the decision to have a recount of all 10 electoral districts predicated upon an agreement which, on the face of it, outsourced the supervisory preserve of the Elections Commission. It is clear from an examination of the case law and other authorities to the cases Kumar, Petrie, and that line of cases, that the issues surfaced in the first category of reliefs prayed for by the appellant, because they may well require the taking of evidence to resolve the presumptions which they make, these issues are best resolved through recourse to an election petition. I do believe, however, and for reasons dealt with more fully in the judgment of the President of this court, that it is the second category which is centered on the agreement and which, in my respectful view, warrants attention. So that while on the face of it, Section 140 prohibits a court from inquiring into conduct, actions, performance, non-performance, and inaction on the part of the Commission, this clause, properly construed, operates as a partial ouster and could not, in my respectful opinion, extend to the agreement which on the face of it fell wholly outside of the constitutional regime and remit of the Elections Commission. The court's supervisory jurisdiction is preserved for such purposes. Confronted then with such an active measure in being at the time, it is my respectful view that it would be remiss of the court to expect the appellant to await the outcome of an election petition to redress this issue. It is my respectful opinion that this development, having been brought to the attention of the court while being actively concerned in terms wholly outside of the scope of the Commission's constitutional remit, warranted the intervention of the court in its supervisory constitutional jurisdiction. And this jurisdiction has long been recognized in our own courts and pronounced upon by Chief Justice, as she then was, Desiree Bernard, and more recently, that is in Hamilton and Alexander and the Attorney General, and more recently, cited with approval by Chief Justice Roxanne George in the application by Holladar. So while ordinarily courts could not and must steer studiously clear of telling GECOM how to supervise or manage the electoral process, the court in its supervisory jurisdiction is in a position to say that it should not outsource its supervisory responsibility in terms that are outside of the scope of its constitutional remit. For this reason, and for others more fully detailed in the judgment of the President of this court, I am in agreement with her finding and with the order she proposes to make. Thank you.
All right. Permit me to dispense with the formalities. We all know why we're here, and I guess you permit me to not to recite in full the arguments, the voluminous arguments presented to this court for its consideration. I'll just get straight into the salient points for consideration here. I will be very brief. I start with the jurisdiction of the full court. The issue of jurisdiction of the full court is raised here for the very first time. It seems that all the parties have agreed and operated on the basis that the order of Holder J on a preliminary point was interlocutory. The appellant here seemingly attacks the jurisdiction of the full court on the basis of Article 133 of the Constitution, which mandates an appeal as of right to the Court of Appeal from final decisions of the High Court in any civil or criminal proceedings or questions as to the interpretation of the Constitution. The specific wording of Article 133 must be noted in this context. This argument, to my mind, is without merit. The preliminary point raised at first instance related to the court's jurisdiction to inquire into challenges to the decision made by GECOM, as it was argued that Section 140 of the Representation of the People's Act precluded the same. In finding that he had jurisdiction to inquire into the decision of GECOM, Holder J was careful in separating the jurisdictional issue from that of the final reliefs claimed. See page 18, lines 10 to 16 of the appellant's record number 1 of appeal. It is interesting to note as well that at page 33 of that record, Holder J states, "I note that this application is being made on an interlocutory application," unquote. Holder J was of course referring to the application for a stay consequent upon the ruling on the preliminary issue. It is clear there was no attempted interpretation of the Constitution in respect of the jurisdictional issue. Indeed, no argument in that regard was proffered. Again, caution must be exercised in distinguishing a claim as one for interpretation of the Constitution as opposed to its mere application. That caution was urged and applied in Harkisoon against the AG of Trinidad and Tobago, 1988 C-265. Holder J merely ruled on that jurisdictional issue which had no bearing on the interpretation of the Constitution, as is mandated by Article 133. Further, Holder J's order could not be said to be a final order, again, as mandated by Article 133, and of course, Section 2A of the Court of Appeal Act. The determination of what is a final order as opposed to an interlocutory order is essentially governed by the application test. Any in-depth analysis here on this issue would merely serve academic purpose, and I resist such a temptation. However, in Salmon against Warner and others, 1891 1 QB 734, Fry LJ succinctly stated, "I conceive that an order is final only where it is made upon an application or other proceeding, which must, whether such application or proceeding fail or succeed, determine the action." Conversely, I think that an order is interlocutory where it cannot be affirmed that in either event the action will be determined. C2 White and Burton, 1894 1 QB. This approach was approved by Chancellor Bernard, as she then was, in the matter of American Life Insurance Company Limited, Civil Appeal number 8 of 1996. Again, in Nova Scotia Manufacturing Company Limited against Orion, 2015, 85 WIR 423, Chancellor Singh, in adopting the application test, stated, "We agree that this was not a final order for the reason that the order made was as a result of an application in relation to an issue that was preliminary to a final hearing and was therefore clearly an interlocutory order." Clearly, the order made by Holder J did not fall within the ambit of Article 133, and as a consequence, leave is required. And I would agree with my learned brother that leave is granted for the reasons that he had stated. More importantly, the full court properly assumed jurisdiction to determine that appeal from Holder J's preliminary ruling. In closing on this issue, the recent pronouncement by CCJ in Passad versus Nizamuddin has not escaped my attention. In the context of Section 61A1 of the Court of Appeal Act, the CCJ held that on the facts and circumstances of the case under review, which was commenced by a fixed date application as presently obtained, and determined expeditiously without resort to the more elaborate and regular process followed generally in matters commenced by statement of claim, such a proceeding would be properly designated as a summary proceeding. I merely mentioned this in passing. the constitutionality of Section 22 of the Elections Law Amendment Act. Again, the constitutionality of Section 22 is called into question here for the very first time. It is noted that the fixed date application that initiated these proceedings makes absolutely no reference to this claim, nor was it canvassed below. This is an unacceptable state of affairs. The constitutionality of an act of Parliament is presumed, and the burden of proving otherwise is a heavy one. See Mutu again and the Attorney General of Trinidad. The authorities are many and clear on the issue of advancing new grounds or points of law for the first time on appeal. In the Court of Trinidad and Tobago against DABAN 2019 UK PC, this issue was explored. At paragraph 26, the board had this to say: "It is well established the board will generally not allow a party to raise a new point on an appeal before it." In Barker against R 1975, 3 All England Reports 55 and 64, the board said that its usual practice was not to allow the parties to raise for the first time in an appeal to the board a point of law which has not been argued in the court from which the appeal is brought. Exceptionally, it allows this practice to be departed from if the viewpoint of the law sought to be raised is one which in the board's view is capable of depending on the appreciation of matters of evidence or of facts of which judicial notice might be taken, and is also one of which, in the board's view, they would not derive assistance from learning the opinions of judges of the local courts. C2 Colonial Life Insurance Company Limited and Gold and others. Now again, in Samuels against GT&T, CCJ Appeal number 2014-008, the CCJ had this to say. I wouldn't read the entire quote, but just raise the salient aspects. To allow Mr. Samuels to challenge the validity of GT&T's license in these proceedings would be manifestly unfair to GT&T. This is simply not the pleaded case that GT&T was called to answer. Mr. Samuels gave no notice to GT&T that wider public interest issues such as the legality of monopolies and the infringement of constitutional rights were at stake. It goes without saying that the principles of fairness and justice must be considered from the standpoint of all the parties to litigation. And again, the learned justices stated, and I quote, "We note also that neither the state nor the director of telecommunications, both of whom would have an interest in the resolution of this issue, is a party to the appeal." Further, in Eaton against Brand County Board of Education, 1997, 1 SCR 2421, Supinka J. noted, "In our constitutional democracy, it is the elected representatives of people who enact legislation. While the courts have been given the power to declare invalid laws that contravene the Charter and are not saved under Section 1, this power is not to be exercised except after the fullest opportunity has been accorded to the government to support its validity. To strike down by default a law passed by and pursuant to an act of Parliament or the legislature would work a serious injustice not only to the elected representatives who enacted it, but to the people. Moreover, in this court, which has the ultimate responsibility of determining whether an impugned law is constitutionally infirm, it is important that in making that decision, we have the benefit of a record that is the result of thorough examination of the constitutional issues in the courts or tribunal from which the appeal arises." Now, the authorities cited in support of the unconstitutionality of Section 22 are involved and complex. The issue as a whole would, as of necessity, require the fullest assistance of all concerned, including the Attorney General, whom pursuant to our CPR must be given notice to defend the legislation. There is no evidence that this was done, and the AG is certainly not a party to these proceedings. Additionally, a determination of the issue may also require evidence to be placed before the court for its consideration. A consideration of this new ground at the second appellate level may completely change the nature of the case canvassed below. Significant prejudice would operate against the respondents present, and I note those who are absent, and the unfairness to the courts below would be palpable. In the circumstances, I am unable to accede to the invitation to consider this completely new ground. I can conceive of no exceptional circumstance in operation here to permit this course. 3, discretion to hear the appeal. The law is clear on this issue. Only in exceptional circumstances would an appeal against an interlocutory order be heard during the pendency of proceedings. See Burkett and James, 1977, 2 All England Reports per Lord Diplow. There seems to be no authority that sets out in any definitive way what are exceptional circumstances, and maybe for good reason. One may be incapable of conceiving exhaustively whether in general or specifically such circumstances. To my mind, the exercise of the court's discretion ought not be fettered, and such the discretion should be exercised on a case-by-case basis. It is clearly within the court's discretion to determine whether or not to proceed to hear an appeal against an interlocutory order. I am unaware of any legislative bar thereto. On this issue, the full court held, and I quote, "In this appeal before this court, the singular determination of the question of jurisdiction will decide if this case goes on to hearing into the substantive issues. In our view, this amounts to an exceptional circumstances permitting the exercise of the discretion to hear this appeal. The ruling by Holder J is not one that is merely interlocutory, and for the purposes of the case, as regards, for example, parties to be heard, pleadings or evidence to be led, it speaks to a more fundamental issue, whether the High Court has jurisdiction to hear the FDA. It goes to the root of whether the matter should be proceeded to at all. And let me step aside a bit here. Reference and some contention was raised in relation to Her Honor's, the Honorable Full Court's reference to the order made by Holder J as not one that is merely interlocutory. And I gather and I interpret that to mean that the Full Court was saying it was not one of the routine or usual applications made on an interlocutory order, but nevertheless, it was an interlocutory order. Having regard to all of the circumstances of this case, including its national importance, I could not fault the learned justices of the full court in exercising their discretion in the way in which they did. Challenges to the jurisdiction of pending proceedings warrant immediate intervention, and plainly there is no public interest in proceedings continuing which are unlawful. See Ferguson and others against the AG and DPP. It is tried that an appellate court could not interfere with the court's exercise of its discretion unless it can be demonstrated that it was plainly wrong. The fact that another court may have exercised its discretion in a different manner is irrelevant. See Sankar against the GRDB and Rodriguez Architects against NBS. Suffice it to say that I agree fully with the full court's analysis of the authorities and their subsequent exercise of discretion. I can conceive of no circumstances which is more exceptional than that which operates here. Now, the jurisdiction of the High Court to hear the fixed date application. This issue forms the substantive bone of contention between the parties to these proceedings. I must reveal from the outset that I am in full agreement with the comprehensive analysis, impeccable reasoning, and irresistible conclusions arrived at by the full court. My intent here is merely to reiterate or supplement those conclusions, as the case may be. It is clear, and ought not be subject of any serious contention, that the declaration sought and consequential orders that engage the attention of the court below concerned a political agreement between His Excellency and the leader of the opposition to have a CARICOM supervisory count of those ballots cast at the March 2nd national and regional election. To my mind, the issues that fall for consideration and the orders and declarations sought are incapable of disaggregation when one peruses. It is clearly within the court's discretion and to determine whether or not context March 2nd national and regional. Now, the various provisions which empower, specifies and guides GECOM's role in carrying out its mandate is comprehensively set out in the decision of the full court. See pages 19 to 23. In an effort to avoid unnecessary repetition, I will decline to do so here. Article 162(1)(a) and (b), a fundamental democratic pillar, vests in GECOM wide-ranging powers as it relates to the supervision over the registration of electors and the administrative conduct of all elections. More importantly, perhaps, GECOM is mandated to ensure an impartial and fair election process. Throughout the legislative provisions, mechanisms are put in place to ensure compliance, to facilitate and to ensure compliance with Article 162. Section 140 of the Representation of the People's Act precludes a court from intervening and interfering in GECOM's decision-making process, except by way of elections petition. Of course, caution must be exercised so as to avoid trespass on the functions of the Commission as endowed by Article 162. Cases such as Petrie and others against the Attorney General, Sekumar Singh and Butler have concretized the scope and ambit of the High Court's jurisdiction in this regard. Petrie, decided in excess of 50 years ago, is well known to all and remains good law up to the present time. See Christopher Ram against the Attorney General. The significance of the elections, quote-unquote, elections process period is of particular importance in relation to the legislative scheme. The purport and scheme of those various pieces of legislation must be fully appreciated and the mischief intended to be guarded against understood. The application of highly technical methods of construing these pieces of legislation without such an appreciation can only lead to interpretative unlawfulness, the application of which could invite dire consequences. In the context of the arguments presented here and below, I move on, sorry. Now, in the context of the arguments presented here and below, the use of the word performed validly or at all in section 141 refers clearly to the performance or the failure to perform. The exclusive and specialized jurisdiction created by Article 163 clearly refers to unlawful acts or omissions. See Article 163(b)(1). C2 Rule 3.1 of the National Assembly Validity of Election Rules, which refers to the exclusive use of an election petition to test whether the result of an election has been affected by any unlawful act or omission. Any argument that attempts to exclude one, that is an act or an omission, pursuant to their interpretation of legislation, is unmeritorious. These are inextricably interwoven. Now, it may be apt to mention here, if only for the sake of emphasis, my full agreement with the full court in distinguishing Holidar against the returning officer 2020 Civil 360, rendering it wholly inapplicable to the present case. See pages 24, 25 of the full court decision for their analysis. Ouster clause. Section 141 can only be lawfully interpreted as a partial ouster clause as opposed to a complete ouster clause contemplated by the seminal decision in Ann's Minute, which requires, and we quote, a provision ousting the ordinary jurisdiction of the court must be construed strictly. In the latter case, any error of law which goes to the jurisdiction will render such a clause wholly ineffective. Section 141 as a partial ouster clause does not completely oust the jurisdiction of the court. It is an integral cog in the statutory wheel or scheme which prohibits inquiry into whether the Commission has performed its functions lawfully or at all, other than by way of elections petition. CRA against Director of Establishment of Security Services, paragraphs 18 and 20. This would include whether GECOM did act upon the political agreement between His Excellency and the leader of the opposition, the extent to which they did, and its implications as it relates to the lawfulness of their conduct during or present election process. Credible affirmative evidence would be required. Again, at this stage of the elections process, issues as to the constitutionality of the relevant legislative provisions could only be examined by way of elections petition, as is permissible and was done in Esther Pereira against Chief Elections Officer et al., 36P of 1998. C2 Peters and Chaitan against the Attorney General, 2001, 63 West Indian Reports, 244. In the circumstances of our legislative prohibition, any approach to the court during this election process may amount to an abuse of the court's process. Again, see AG and Dumas, 2017 UK PC at paragraph 12. The court, while zealous to resist restrictions on their jurisdiction, draws a clear distinction between legislative attempts to oust judicial control over the illegality of decisions and legislation, which has the function of allocating jurisdiction to a particular judicial body, provided, of course, that there is an effective judicial control, as there is in this jurisdiction. C. D. Smith, Judicial Review, 7th edition, paragraph 4015 to 4016. Now, these are my brief comments. In closing, I wish to endorse the view expressed by the full court at pages 28 to 29 of their decision, paragraph 100. And I quote, "This court is of the view that the filing of judicial review proceedings undermines the legislative process, which affects finality in the elections process. We are quick to point out, however, that finality does not mean lawfulness. Lawfulness can always be challenged by way of elections petition. On this point, it is clear that the filing of these judicial review proceedings has had the contrary effect to facilitating the efficient completion of the 2nd of March 2020 national and regional elections. This is a clear demonstration of the type of mischief which the legislature intended to address by providing in plain and simple language that these challenges should be addressed by election petition. The entire scheme of the legislative matrix points significantly to the fact that the elections process must swiftly and efficiently take its course so as to enable the election results to be declared. End of quote. In the circumstances, this appeal is dismissed as I find no merit in the appellant's submission. And the decision of the full court dated the 31st of March, 2020 is affirmed.
Yulita Moore approached the High Court by way of fixed date application, seeking several reliefs, 25 reliefs to be precise. Yeah, she sought several orders from the High Court. The matter came up for hearing before Holder J, who granted the interim injunctions she sought. During the arguments, the seventh named respondent contended by way of an application before the judge that the court had no jurisdiction to grant the several reliefs being sought by Ms. Moore. In short, the seventh named respondent argued that these reliefs should be sought by way of election petition. It was contended that these matters involved the conduct of elections and fell within the class of cases set out in Article 163(1) of the Constitution, which created a special in an elections petition to be filed subsequent to the declaration of the results of the election. And the part of Article 163, which I think applies in the circumstances of this case, is Article 163, 1B. And that will be B2. And the question would be whether either generally or in any particular place an election has been lawfully conducted, or the results thereof or the result thereof has been or may have been effected by any unlawful act or omission. So that was the portion of the article that seemed to be applying in the circumstances of the case. In opposing the application, Ms. Moore, that was the application to make submissions on jurisdiction. In opposing the application, or that the case should be struck out for want of jurisdiction in the High Court, in opposing the application, Ms. Moore argued that the matters involved constituted issues on the power of GECOM in its conduct of elections and ought not to warrant an elections petition. She thought it involved issues involving the constitutional jurisdiction of GECOM, the constitutional powers of GECOM, and so she resisted that contention that the High Court had no jurisdiction. Holder J ruled that he did have jurisdiction to hear the issues before him and put the substantive matter down for hearing thereafter. At the end of the judge's ruling on jurisdiction, the seventh named respondent appealed to the full court against the ruling on jurisdiction. He applied for several orders, the main ones being a declaration that the learned trial judge did not have jurisdiction to proceed with the matter. After hearing, the full court conducted the full court concluded that the High Court could not entertain Ms. Moore's application, agreeing that her case involved issues that ought to be the subject of an elections petition. The full court dismissed the case that was pending before Holder J, and also set aside the interim injunctions that he had granted and refused a stay of the full court's decision pending the hearing and determination of an appeal to the Court of Appeal. Dissatisfied with the ruling of the full court, Yulita Moore now seeks leave of the Court of Appeal to challenge the decision of the full court. In the notice of motion, the intended appellant seeks a number of orders, they're not many, that there be leave, that the application for leave be treated as the hearing of the appeal itself, that there be an early and expedited hearing of the appeal. So that she claimed that the full court wrongly dismissed her application and that the decision was bad in law and that she ought to be granted leave to file an appeal against that decision. So in relation to her application for leave to appeal, Mr. Scotland, for the applicant, submitted that in respect of Section 62A of the Court of Appeal Act, the question was whether the order was final as opposed to interlocutory. If the order is final, but it falls under Section 62A1, the appellant would have no right would have a right of appeal to the Court of Appeal. Referencing Chung, if it fell under 62A1, she would have no right. And referencing Chung against AIC Battery and a decision of the Caribbean Court of Justice, he submitted that a final order was won which finally determined the rights of the parties. Noting that in this case, the seventh respondent's appeal arose during the course of the hearing of the fixed date application on a preliminary point of jurisdiction, he said that although the appeal was by its very nature an interlocutory one, the orders of the full court upon the dispensation of that interlocutory appeal gave rise to final orders. Counsel argued in the alternative that if the applicant's appeal does not fall within the Section 6.2 category of appeals, then Section 6.4 gives the applicant the right to seek leave to appeal, and he placed reliance on Guidon and others against Republic Bank. So I wouldn't go into those two pertinent sections. I believe they are well known, quite often referred to in this court. And Counsel said that even if it is found that the decision of the full court is interlocutory, the applicant can seek leave of the Court of Appeal by virtue of Section 6.4. In response, Mr. Mendez accepted that the full court's order was a final order, although the appeal before the court was from an interlocutory ruling made by a judge of the High Court. Mr. Mendez, however, argued that this was a final order given in summary proceedings and therefore cannot fall under Section 6.2a1. Counsel cited the case of Assad against Nizamuddin, a recent decision of the Caribbean Court of Justice, in support of the contention that matters commenced by a fixed date application and determined expeditiously without employing the regular process are in effect summary matters. In these circumstances, he argued, there is no right to appeal and under Section 6.2a. Well, in my view, both of the submissions, to my mind, have merit in that the matter did proceed to the full court on appeal against an interlocutory order, and while in the full court it was not disputed, the matter was finally disposed of. So, however, if the court could look at it as originating from an interlocutory appeal, and therefore the full court orders or decision should be viewed as an interlocutory order, or it can be seen for the nature of the order that it was. And so I feel that either way, the applicant ought to be granted leave to appeal, depending on how one views what is under appeal. The court also takes note that the full court, in dismissing the case, finally determined the applicant's rights. The full court finding of no jurisdiction ultimately ended the proceedings for her and left her with no alternative to ventilate her case but to approach the Court of Appeal. She had nothing to go back to the High Court to. So, as I said, I've looked at it from both angles, and she is granted leave to appeal. Now, as regards the application for the urgent hearing, not much needs to be said about that because the parties accepted that the matter was an urgent hearing. All parties agreed that it required disposition in a hurry in light of the circumstances in which the nation is currently engulfed. And it might be noted that in our practice direction, Practice Direction 1 of 2020, all matters related to elections have been deemed urgent. And so on that administrative basis as well, we believe that an urgent hearing was quite justified. And in addition to the urgent hearing, the court will treat the application for leave as the hearing of the substantive appeal. I had raised the issue of jurisdiction of the full court, and I had made a few observations. I do not intend to make it an issue in these proceedings, but I do make the observation that the applicant's matter was described in her fixed date application as one for judicial review, and that it did involve constitutional questions, and those questions involved the ambit of the powers of GECOM as contained in Article 62 and 162.1, and involved the question, it involved public law functions which were performed by GECOM and the officials in the Elections Commission. Those are public law functions. And also involved was the question whether the Commission had lawfully performed some of its functions, those public law functions. And this was functions under the representation of the People Act and the Elections Law Amendment Act. And so I believe it is fitting to make the observation that traditionally, or the full court has always been known to be a court that deals with procedural appeals, interlocutory appeals, and not appeals in public law cases, certainly not appeals that involve judicial review. But the question is whether the appeal should have come directly to the Court of Appeal. I make the further observation that in any event, the substantive matter is now before the Court of Appeal, which is in a position to make whatever orders it feels were appropriate in relation to the claim. Now I come to the substantive appeal. Well, an examination of the claims made by Ms. Moore reveal that she made several claims, as I pointed out, 25 claims, and her grounds of appeal really raise four main issues. And the first is whether the High Court had jurisdiction to inquire into the matters set out in the application, or whether they were matters for adjudication by way of an elections petition. The second issue is whether Section 14.1 of the Section 140.1 of the Representation of the People Act ousted the jurisdiction of the High Court, and whether there was a narrow that's the third issue, whether there was a narrow constitutional jurisdiction to inquire into any part of the claims made in this matter. And finally, whether Section 22 of the Election Law Laws Amendment Act 2000 is unconstitutional. And I was saying earlier that the reliefs which Ms. Moore sought in her application to the High Court comprise claims that the respondent officials of the Guyana Elections Commission had no authority to accede to any request for a recount of the votes cast by electors in the 10 electoral districts on the basis of an agreement between the President of Guyana and the leader of the opposition. She claimed that certain steps having been taken by the returning officer under the Representation of the People Act and a report having been prepared for the Chief Elections Officer, these triggered duties under Article 177, which provided for the declaration of the winner of the presidency, and under Section 99 of the Representation of the People Act, which provided for the allocation of seats in the National Assembly. So when I examined her individual claims, those were the elements that I saw in all her claims, but arranged in various ways and making other types of complaints. But I think that those were the core elements of her claim. Now, counsel for the appellant, that's Mr. Scotland, stated in his written submissions, he gave as one of two pillars of his case, two main pillars of his case, that the votes cast, which is confirming what my observation is regarding Ms. Moore's, the elements of her case. Counsel said that one of the two main pillars of his case was that the votes cast at the election, having been duly counted, and requests for recounts of those votes having been duly refused, there may be no further count or recount of those votes. He says that the presidential candidate elected should be declared by the chairman in accordance with Article 177 of the Constitution, and the GECOM should make a public declaration of the results of the elections for members of the membership of the National Assembly in accordance with Section 99 of the Representation of the People Act. As against the chairman, counsel in his submissions made several complaints of failure to perform her functions under Article 177. And he also highlighted other consequential failures on her part, having failed to perform her functions under Article 177. And as against the other officials of GECOM, he complained, this is counsel complained, of failures to make the declaration of the results of the elections under Section 99. So that the key aspect of Ms. Moore's complaint was the issue of the recount and whether the time had come for the Commission to move along the steps that were provided in Article 177 and Section 99, among other sections. But the chairman of the Guyana Elections Commission did make submissions which were part of the record and did in fact also depose to an affidavit. And she pointed to her powers on the Section 22 of the Election Laws Amendment Act 2000, the Representation of the People Act, and the Constitution of Guyana. And those powers that she referred to were the powers in her powers, GECOM's powers on the Article 62 and 162 of the Constitution. Article 62, I wish to read that elections shall be independently supervised by the Elections Commission in accordance with the provisions of Article 162. And Article 162 is a more elaborate provision, but essentially Article 162 1B provides for the places a responsibility on the Commission to supervise the elections and to ensure fairness and impartiality. So the chairman pointed to those powers and duties, and it is indeed clear, as she contended in her submissions, which were part of the record, that it was the duty of the Commission to take such action as appeared necessary to ensure its duty of impartiality and fairness and compliance with the provisions of the Constitution. And she did, as I said, point to those responsibilities. So in the context of those powers, the matters falling within Article 163, 1B, those are the matters concerning the, as I mentioned earlier, conduct of the elections. I wouldn't go back and spell it out, but in the context of those powers, if complaints are made, then it would appear that complaints of that nature would be justiciable by elections petition. It follows that the appellant's claims that certain acts triggered actions under, that is actions by the officials, GECOM and the chairperson and other officials under Article 177 of the Constitution and Section 99 of the Representation of the People Act would not necessarily be triggered as claimed by Ms. Moore, because there was a responsibility to ensure fairness, and those were constitutional duties. And so it could not be that once a certain stage had reached in the process that it was automatic that the process would move to Article 177 and Section 99. So that to the extent that Ms. Moore asserts that duty on the part of GECOM and the officials, her claim cannot be sustained. So that's the answer on the first question. I will be expanding on my judgment, the time I issue it, or I publish it. My answer on the second issue, and that is Article 140, whether it ousted the jurisdiction of the High Court. And in summary, on this aspect, I agree with counsel for the appellant, that is Dr. Alexis, as to the nature and operation of the ouster clause contained in Article 140. However, I disagree with him, as I said earlier, that the appellant was entitled to an exercise of the jurisdiction, the type of jurisdiction that was exercised in the Ventos case, which counsel said the appellant was entitled to. Although I accept his submissions regarding the nature of the clause, I do not accept that that clause enabled the High Court to make the types of orders that counsel urged the court to make. I believe that in the context of the constitutional powers which are contained in Articles 62 and 162, 1 and 1B, those powers of the Commission, that and the scope which those powers allow when it comes to ensuring the process is as Constitution requires it to be. The jurisdiction of the High Court is not a jurisdiction of the type that was exercised in Ventos. In my view, the inquiry which was allowed by the High Court was one more in the nature of that exercise in Patfield against the Minister of Agriculture, because those powers, the High Court's jurisdiction, would be subject to the powers that the Commission has under Article 62 and 162. So it could not be that white power, as Ms. Moore claims, that the court must order the Commission to move the Article 177 or Section 99. I think the power was more restricted, but that jurisdiction did exist. Now, it is for that reason now that I come to the third question, whether there was a supervisory jurisdiction, a constitutional supervisory jurisdiction in the High Court, for the very reason that those powers are in the court has to be cognizant of those powers that GECOM exercises. It is for that very reason, on that basis, that it must be considered whether there is a constitutional jurisdiction to ensure that those powers are preserved. And to my mind, the other side of the coin is that there must be such a power to ensure that those duties are being observed. So while the Commission must be allowed to perform its functions, certainly the High Court must have the power as well and the jurisdiction to inquire whether those functions are being performed as the Constitution mandates. So in her affidavit in support, Ms. Moore highlighted a media release. She highlighted that throughout her claims, she has made reference to that agreement, the agreement between the leader of the opposition, the president and the leader of the opposition, in relation to arrangements for a recount. And to my mind, that agreement must be, could be delinked from the rest of her claim, because she points out the contents of that agreement sufficiently in her affidavit to establish that it is something that could be inquired into. And I observe that she gave those details about the media release and the statement in that release that the supervision of the recount would be undertaken by a team. And she complained about that. And that, those assertions were supported by Mark France in his affidavit in defense. He confirmed that there was that media release that spoke of the supervision by the team, and he exhibited to his affidavit that release, and that release indeed did speak of the team supervising the recount, and use words such as oversight. And so, to my mind, such facts or such assertions must have triggered the supervisory jurisdiction of the High Court to see whether those functions and powers under Article 62 and 162 were being compromised or reduced by the terms of that agreement. So my view is that it could be delinked from the rest of the claim and inquired into by the High Court, because there were facts on which the court could have inquired. Well, based on which the court could have inquired, and I mentioned where those facts could be found. And there were other references to that release. And so I believe that the particular arrangement regarding supervision in the context of the constitutional powers of GECOM, those arrangements could have attracted the supervisory jurisdiction of the court. So, on the other question as to Section 22 of the Election Laws Amendment Act, based on the order that was made under the Act, that order enabled the Elections Commission, as I saw it, to exercise the powers that, or powers of the nature which it was given by the Constitution. And so my view is that there was nothing unconstitutional about Section 22, but certainly, even if one might argue that the orders that were made under Section 22 were not, in my view, or the order was not an unconstitutional order. In fact, it enabled arrangements to be made for the recount. So I reject the argument that Section 22 was unconstitutional. Section 22 of the Election Laws Amendment Act was unconstitutional. And as I said, those are, now in relation, coming back to that issue about the jurisdiction of the High Court, and the question is whether Holder J had that jurisdiction. And I think he recognized that he did have that jurisdiction in his judgment. We have a transcript of his judgment, and in much of his ruling, he referred to that agreement, and he felt that he had the jurisdiction, but he did not go on to exercise it or to assess the nature of that jurisdiction. But as I have said, the jurisdiction of the High Court's a narrow jurisdiction. It was invoked by the description of the authority of the team relative to the constitutional powers of GECOM. And so the question is, even if Justice Holder had been allowed to finish and exercise that jurisdiction, it could have been no more than a jurisdiction to indicate or to inquire what was the nature of the arrangements and to express the unlawfulness of any arrangement or agreement which took away GECOM's power of supervising the elections and placed that power on any aspect of GECOM's power, of GECOM's supervision in the hands of anyone else. So it would have been a power to declare it unlawful. And of course to satisfy himself about it. And if he was satisfied to have declared it to be an unlawful exercise of the, or it could have been in breach of GECOM's powers to have allowed that agreement. And so he would have, had he been allowed to exercise that jurisdiction, he would have had to correct and to order that that relationship be considered, be adjusted to reflect that GECOM is the constitutional body charged with the supervision and management of elections. He would have, in my view, had that power. And I think he recognized that in his judgment when he ruled on the agreement. And so, as I said, I will expand on some of the issues I've raised, I've discussed in the judgment. But those are my reasons on all the aspects of this appeal, the application for the leave to appeal and so on, and on the substantive issues. So my order, in concluding, is to allow the appeal in a small part, obviously because what I've just said about those powers. I do not agree with the full court that everything was to be referred to the elections court. There was sufficient before the High Court to have triggered the supervisory jurisdiction, constitutional supervisory jurisdiction. And so with that exception, I would, well, essentially dismiss the appeal with that exception. And of course, to also stress that the power of the High Court would always have been to say to the Guyana Elections Commission that any arrangement or agreement to relinquish supervision of any aspect of the elections, whether the recount or any other aspect, any arrangement to relinquish that supervision and authority would be an unlawful arrangement. GECOM must at all times remain the body constitutionally mandated to supervise. And so that is my judgment in this matter.
I want to oblige you, Malady. I want to invite you to ask you a clarification. I imagine that we will eventually see the terms of the order that you're making, but I was just wondering if the effect of the court's order is that the High Court can only inquire into the question whether
supervision.
recount is being conducted under the supervision of CARICOM.
Well, I didn't put it like that. I say that any aspect of the management and the supervision of the conduct of the elections is the responsibility under the authority of GECOM, and GECOM cannot relinquish its supervisory authority to any other body, whether in the recount or in any other aspect of its management of the elections. That is my understanding.
In other words, if GECOM, I'm just trying for clarity, John, if GECOM were to say that the recount will not be conducted under the supervision of CARICOM or anyone else, then the High Court will not have jurisdiction to review its order for a recount. Is that how I understand?
That is my understanding. That is how I understand the position, that it is within the ambit of GECOM's powers to, in the management of elections, it has given itself the power under Section 22 of the Elections Law Amendment Act. And so it has those powers within its ambit, or within the plenitude of its powers. But it must supervise the process. It must not relinquish supervision. That is all.
As long as it does not relinquish supervision, the High Court has no jurisdiction.
That's it. I would say that, yes. Because it has its constitutional powers, and once GECOM stays within the realm of its constitutional powers as well, then I would say the High Court would have no jurisdiction to inquire. But they did have that narrow jurisdiction, having been triggered by that media release and all the contents that were alluded to regarding supervision. Are you clear?
Please, Your Honor, if GECOM is going to have a recount, GECOM is going to have a recount, in circumstances which trigger a complaint under either the RPA or the Constitution, a different situation would arise.
You mean if it acts outside of its powers?
Precisely, yes, Your Honor.
Well, of course. Of course. But GECOM has wide powers.
Yes, admittedly, yes, Your Honor.
Yes. GECOM has powers.
Again, Your Honor, again, for clarity, I'm trying to understand the circumstances under which this court is saying that the High Court intervened. I understood what Dr. Alexis just asked you is if it is being said that GECOM is acting outside of the Representation of the People Act, whether the High Court will have jurisdiction to review that decision. Is this court saying that the High Court would have jurisdiction to intervene if they're acting contrary to the Representation of the People Act, or only if they're acting contrary to the Constitution, and in particular in relation to the part of the order permitting CARICOM supervision? We need clarification, Your Honor, in order to know how, at both sides of the court, in order to know what we should do next.
Well, yes, Dr. Alexis, you have something to say?
Can't hear Dr. Alexis.
And I should mention that I do not propose to send the matter back to the High Court for the exercise of that jurisdiction. This court has described it. It was never examined by the High Court because of the circumstances, but this court has described the nature of that power, the nature of that jurisdiction. And my understanding is that GECOM's powers must be viewed within the context of Article 62 and 162, as well as within the context of Section 99, because Ms. Moore said, well, if you look at her claims, I've looked at each of them, her contention is that because certain things had happened, then the next step must be to Article 177 and Section 99. But the chairman, in her submissions, pointed to the wide powers, or to the powers that the Commission has under Section 62 and 162, and pointed out that the Commission was entitled to take such action as it deemed necessary to ensure fairness and impartiality. So that is within the purview of GECOM, and if a party feels that GECOM is acting outside of the purview, outside of its constitutional authority, then the High Court does have a jurisdiction in its constitutional supervisory jurisdiction to examine those alleged breaches, if any exist. Mr. Mendez, anything else?
I'm not hearing Your Honor at all, please.
What was the last thing you heard, Dr. Alexis?
Not sending the matter back to the High Court.
Yes, I said that although I found that the High Court does have that jurisdiction, that Holder J did have it, I found that he recognized that he had it. When one reads his judgment, he discussed the agreement, but at that stage, the matter was discontinued before him, for want of a better word. So it never was, he never inquired into the agreement, but he ruled that he had the jurisdiction. But I'm saying, given the narrow jurisdiction that it is, there's no point, in light of all the circumstances taking place in the country, I do not see the point in returning the matter to Justice Holder in the High Court, although I acknowledge that he did have that power. But given the urgency, given the critical nature of our circumstances, I would not see that any need or any point in returning the matter to the High Court, because this court has in fact, I think, articulated the scope of the power. I hope I have articulated it, and I hope that I have stressed enough that it is the supervision that triggers that inquiry, the assertion that the court, that somebody else was going to supervise, is what I believe triggered that.
Yes, please, Your Honor. I'm very grateful to the court. The full court made a number of orders set out in paragraphs 103 to 108. I understand from Your Honor that you do not propose that this matter be remitted to Justice Holder because of the very narrow ambit of any possible jurisdiction which Your Honor says he may have. Now, at paragraph 106, the full court ordered that Ms. Moore's application stands dismissed. Does that mean that that order is maintained by this court? If Your Honor does not propose to send it back, my inference, and I ask to be corrected if I need to be, is that the order that it is dismissed stands. If it does not stand, it's got to go somewhere, Your Honor. It cannot be left in limbo.
No, I think the court having ruled in her favor, then it can't be dismissed. Thank you, Mr. Jonas, for pointing that out. It has to be that, well, it might be spent, as my brother is saying, but I believe that the record perhaps would be more accurate if the court grants that order, that any agreement in which supervision of the elections is removed from GECOM and ascribed or given to any other body would be unlawful. She asked for that. She asked for many other things, but she didn't ask for that. And I believe that she has to get that particular order. So that would be my order because of the findings I have made, that I'm granting her that.
May I have the terms of that order, please, Your Honor?
I'm considering whether this court, whether I have the jurisdiction to go back on it. I can just merely treat it as an expression of how this court, of how I see her entitlement, but the matter won't go back, and I would not return to the order. Anyone, her counsel has anything to say on that?
May it please, Your Honor. Your Honors, having heard the decision of the court today, and having regard to the fact that the court has, in fact, allowed the appeal, it appears, to some extent, I do not believe that it is the place of counsel at this stage to, as has been happening so far, to put repeated questions to the court, but to await the court's further analysis of its conclusions it has made at this stage and to reduce them into terms of orders. But my concern is this, Your Honor, is that having decided that the appeal is allowed to some extent,
In part,
to some extent, Your Honor, I respectfully submit that the orders made or the orders requested in the fixed date application, to the extent that they are allowed by the court, ought reasonably to be granted.
well,
The other issue I'd ask the court to consider, and I am not asking the court to do so at the very moment at the bench, Your Honor, is the fact that the court has decided that the appeal is allowed in part, but to some extent, Your Honor, I myself, as the court vocalized it just now, I'm uncertain as to whether, having found that the appeal is allowed in part, and in respect of a jurisdiction which ought to be exercised by the full court in terms of only a jurisdictional point having been raised and brought to this court, whether, despite the court's discomfort, whether the proper judicial approach is in fact to remit the matter back to Justice Holder for the determination of those issues and the exercise of those issues as a court of first instance in that regard. I'm raising it to the court. I'm not asking the court to agree with me, but to consider them, Your Honor.
Well, Your Honor, so far I think Dr. Alexis and myself have simply been asking questions to clarify the order of the court. What my learned friend is now doing is asking you to change your order, which is an appeal. I understood Your Honor to have said that you are not referring the matter back to the High Court. All Dr. Alexis and I have been doing is seeking clarity as to exactly what the orders of the court were. Mr. Ford now is asking you to change your order, and I do not think that it is appropriate for him to be doing so. That is in fact an appeal.
all right, well, the court,
I've not been asking the court to do that. My question flowed from the statement made by my learned friend, Mr. Jonas, in terms of what orders have been, the court is not remitting it, and whether that part of the order and what is happening to Justice Holder's order. I'm just pointing it out.
well, the matter never went to Justice Holder on its merits. It was never considered. But I am willing to hear your further submissions, if you wish, on that aspect, if you think it's important enough. I mean, if you look at the entire trend of how the court has been dealing with the case, it's urgent, and the court respected the situation in the country. We've sat on Sunday, and my view is that we ought not to return to the High Court. We ought to We have expressed, I hope very clearly, what the situation is with, in relation to Miss Moore. So if you wish to address us further on another day, or maybe in writing, you can send a letter, you can have an exchange of letters. We can hear that before we actually prepare our orders. If you wish that, we can hear you by letter.
If it pleases you, I think I was writing down what I understood Your Honor to be saying, to be that any agreement in which supervision of the aspect of the elections is removed from GECOM and given to anyone else would be unlawful.
Yes.
I have Your Honor to
Yes, that is what I said.
Much obliged, Your Honor.
All right, so counsel, if you would like to make further approaches to the court on that aspect, the consequential, well, that if it's consequential, but I'm concerned about the jurisdiction here, in that, yes, the appellate jurisdiction. I'm not sure how, whether as part of the hearing of the appeal, well, we have the same powers and, well, as a full court, but I don't know whether those powers ought to extend all the way down to the court of first instance. But you might want to address us on those things. And it is only for that reason that I would not want to express any orders now. But certainly, if you wish, we can entertain your letters.
Would it be possible to get the court's order today? Because we need clarity as to what happens next. And so it would be useful if it could be drafted, and I'm sure it would have been pre-prepared, just to be entered now so we can have it.
Well, certainly, I don't know how if we are to send letters to the court. Sorry, Your Honor. If we're going to send a letter to the court and the court is going to be considering what the court just mentioned, I'm concerned as to how the order is going to be drafted and what is going to be drafted in it in terms of consequential order. Consequential orders, when the court is saying that it will
But
consider...
Mr. Ford, you have a statement from the court. You have a statement from the Court of Appeal, essentially articulating that right. You want more than that?
Your Honor, my concern is not a statement that has been articulated by the court, but you would have heard repeatedly, beginning with Lawrence Senior Counsel Mendez, he's asking the court that he's seeking clarity because he wants to know what to do next. To do next relates to both sides of the litigation that the court has just determined. And I'm asking the court, Your Honor, the court is indicating that we must respond or submit letters to you in terms of the consequential orders. I find it that the statement made by Mr. Kisoon, that the order be reduced right now, it appears to be to get the order today, seems, I'm uncertain as
well, we
how...
could set time limits for you to send your letter, because given the urgency of the case,
Certainly,
we will have to finish now with the orders.
Certainly.
So how soon will you be able to send those letters? You can email the court. Mr. Ford, how soon?
Your Honor, I believe by 8 o'clock tonight.
Yes, 8 o'clock tonight is okay. We'll get it in the new week. Tomorrow is a work week, but we hope. We're not sure yet. Every day it's one day at a time. But ordinarily the court is working, whether electronically or in person, both. So we will look out for your letter. If you still want to, you still wish to press for your letter, we will certainly receive it and consider it and letter from the other side as well.
Thank you.
Now, of course.
Your Honor, if I may, my learned friend, when he sends the letter to the court, he will send a copy to us at the same time.
Well, yes, we will want to hear from everyone.
And then could the court tell us what time we have to respond to
Which
that?
time do you wish? Tomorrow?
By 8 o'clock tomorrow morning.
Same time that we could apply.
Yes. So we would like to see what he says, to reply. So by 8 tomorrow morning, we should send the letter.
And we will communicate through the office.
At this point in time, we don't have anything to add. Whatever we have to add will be as a result of what Mr. Ford says. That's why we can't do it simultaneously. As Mr. Mendez explained, we are pretty clear on what the order of the court is. Mr. Ford seems to be unclear, so as he attempts to get his clarity, and if there's anything that we can reply to, we would like an opportunity to do so. So by 8 tomorrow morning.
Now, we still have to come to the question of costs, because counsel, the court has been doing a lot of printing.
Your Honor, if we can, could I suggest that you ask the parties to make submissions in writing on costs after we had the opportunity to see the orders that you make, and of course to think about the rulings that the court has made. It's not possible at this point in time to assess exactly what is the most appropriate order without having seen as the cost, that is to say, without seeing the final orders of the court, and of course considering the different rulings that we have made today. But this is my suggestion.
Thank you.
Yeah, by Rosemary, we agree with that suggestion. We agree the order, and we are quite clear as to the order of the Honorable Court as in meeting. Quite clear.
Just to be clear, when will the court deliver its consequential order? At what time tomorrow? For the purpose of
Justification, what?
Well, there's a suggestion from my brother that each party bear her and his own costs. Her and its own costs. But what do you say?
If it pleases your honors, that suggestion by your friend seems to me to make good sense. I'll say why. As regards more, materially we had two main points before the court. One, that the agreement was requiring GECOM to go against the Constitution. And two, we were asking for a Vento's order, ordering the chairman to declare result, and similarly GECOM. We prevailed on the constitutional point. We had other result on the other point. That being so, seems to me that an order that each party bear its own costs would be very fair indeed in this circumstance. Much obliged, Your Honor.
Your Honor, on that question, I will refer to Mr. Nanlal, who would be in a better position to take instructions from the client, and he may already have those instructions, I don't know. So I refer to Mr. Nanlal.
Thank you very much. Your Honor, in principle, I don't see any objection. I don't oppose the suggestion made by Justice Prasad, and which seemed to have found the acceptance of Dr. Alexis.
All right, so the order of the court is that each party bear its own costs, and we await your contributions on the orders. Well, the order as the other order, which is the constitutional order. And you would bear in mind the timelines that we have we have just set.
So, Your Honor, after you would have received the benefit of our input, what time tomorrow we can anticipate?
We will be in touch with you through telephone, email, electronically. We're not convening a court again just to...
I know, so but can we assume that tomorrow self we will get the final order of the court?
Well, once you do your part, the court is very connected, and so once information comes into the registry, the judges are immediately contacted. So it's up to you.
Well, we will put our stuff to the court by 8 o'clock tomorrow
We
morning.
will try to respond and come up with an order by tomorrow afternoon. Okay, judge is saying by 1:30 tomorrow.
1:30, that's okay. Thank you very much.
Well, thank you very much for your submissions. Thank you very much for your soft copies. They have been very helpful, and we hope to clarify with a more expanded judgments. And who knows if we may have to get our judgments in order very soon. I don't know how the parties feel about their rights. All right then. So thank you very much. Thank you.